Session.
Thank you, Ms. Kraft. Gentlemen, we want to thank you before we get started, you and your clients, for agreeing to participate by way of Zoom oral argument. I know it's not the way that we previously have done business, but it is the way that we need to do business at this point in time, and I appreciate you being able to work with us on that part of this. I want to remind you that all the protocol, the procedures that we would utilize as if we were in court will be utilized today. So just please consider yourself in court at all times. Obviously, that means that each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved time previously with Ms. Kraft, you'll receive that time to do your rebuttal. Before we get started, I want to introduce our panel for today. The panel consists of Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Ms. Kraft, anything we need to take up before you call the case?
No, Your Honor.
If you would, please call the case then.
Be Teresa McCain versus St. Thomas Medical Partners.
Thank you. And we will now hear from the appellant.
Good morning, Your Honors. My name is Patrick Parker, and I represent the appellant, Teresa McCain. I had previously reserved 5 minutes of rebuttal time with the clerk.
All right. Thank you, sir.
Appellant is before this court today, Your Honors, appealing the grant of summary judgment at the trial court level based on plaintiff's complaint for violations of the Tennessee Human Rights Act codified at TCA 4-21-101. In that complaint, Ms. McCain asserted violations of the THRA consisting of hostile work environment, sexual harassment, and retaliation. Appellee moved early on for summary judgment prior to discovery of depositions. And in August of 2019, the trial court granted its first motion for summary judgment order, stating that any claims under the THRA that plaintiff asserted arising on or before September 6, 2016 are dismissed. And in there also stating that the continuing violation doctrine of any events occurring prior to that same time period would not be considered by the court in evaluation of any of plaintiff's Tennessee Human Rights Act claims. Plaintiff was further limited to the singular issue of whether plaintiff's remaining issue is to be whether plaintiff suffered an actionable constructive discharge on September 12, 2016, when she resigned from her employment arising from the events of September 6, 2016, and if so, whether or not she's entitled to damages. After further discovery was taken, the defendant moved for a second motion for summary judgment, which was heard in May of 2020, at which time the plaintiff case was finally ruled on and dismissed when the court ruled that plaintiff's transfer to another work area at her employment was not an adverse employment action, and therefore she did not have a retaliation claim. We are appealing that appellant's THRA claim should not have been dismissed and limited only to the events occurring on or after September 6, 2016. As cited in the appellant's brief, the appellant suffered direct sexual harassment from a co-doctor within the practice which she worked, a Dr. May, that did include physical touching and direct sexual advances in the workplace. Appellant is not appealing the direct sexual harassment of those acts, but rather what occurred and the hostile environment that occurred as a result of those acts after that period of time leading up to her constructive discharge in September of 2016. And that is where we get into these facts that relate to the continuing violation doctrine. At the time of the dismissal, the defendant relied heavily on the case of the Spicer case, Tennessee Supreme Court case, which does limit cause of action to actions occurring within a 1-year period of time. However, that case was subsequently modified by the Supreme Court in the case of Booker versus the Boeing Company, cited at 188 Southwest 3rd, 639, which amended Spicer in stating that a continuing violation rule does occur under two sets of circumstances. And those circumstances are either whether the unlawful employment action was continuing and continued to occur related to the last act prior to the filing of the case. And what the plaintiff is alleging here is that after the harassment occurred, she reported the harassment, and then an investigation ensued. She was suffered to a hostile work environment from co-employees within the workplace, and then also was subject to increased scrutiny from her direct supervisor. And all of those facts led up to when she was moved within the workplace, her constructive discharge event when she resigned on September 12th, 2016. Under the continuing violation doctrine, the 1-year statute of limitation is measured from the time the continuing discriminatory conduct ceases. Okay, not from when it occurred. So it was continuing and did not cease up and through when she was moved from her employment on September 6th to a different work area. She was going to be working for a different physician within the practice, a physician that she had not worked for previously. She previously was working for one of the most high-profile doctors within the practice, and had a good work environment, good work history with that doctor that she was working for, only to come back to her employment to learn that she was being moved and had no reason for why she was being removed. There was no explanation.
Mr. Parker, let
Yes.
me ask you a question. I want to make sure I understand what you're saying. Are you saying that the continuation of these activities or the last act in the continuation of activities is the transfer? Is that it?
It was the transfer and then her resignation. She submitted her resignation. So it would be the transfer and then subsequent her resignation on September 12th, 2016. And I would, I'm sorry.
Let me ask just a follow-up question here. So explain to me how the transfer in and of itself is part of this unlawful activity against your client.
After my client filed a claim of discrimination, the employer came in and conducted interviews within the workplace of various different employees. Those employees took hostile actions against my client after those interviews, and she began to be treated differently within the workplace. Her supervisor also.
Was this prior to the transfer?
This is prior to the transfer.
Okay.
So this was ongoing in the workplace at the time. She had no notice of any results of any of the workplace investigation, the results of that investigation. In fact, Your Honor, the doctor was who perpetrated the direct harassment was investigated by a peer review committee by the doctors, whereas the co-employees were investigated by the management group for the practice. So there was never any clear indication of what the result of the investigation was. Plaintiff then did leave her employment and was granted FMLA leave for a period of about 4 to 6 weeks after a car accident she had. And when she returned from that employment, that's when she was moved to a different position. She was moved from her position that she had before, and she was transferred to a different doctor to perform her duties within the workplace. And it's that transfer that she was not giving any why, what, or any reason for, that she related back to the events that occurred because she had reported the discriminatory acts of the doctor against her. And then she was moved, and then she submitted her letter of resignation on September 12th. And so if you, with the case cited in our brief stating that she was a resignation can be considered under reasonable circumstances an adverse employment act, is Gordon versus W.E. Stevens Manufacturing that cites that that came out of this court, stating that a resignation would in fact be considered an adverse employment action.
Let me ask you, Mr. Parker, is it the last adverse act by the employer that triggers the start of the running of the statute of limitations? Because as I understand under the facts, the last time your client actually worked there was September 6th when she was transferred. And according to your brief, you say that was the last adverse act by the employer. Why wouldn't that date trigger the running of the statute of limitations as opposed to the date that your client sends her resignation? Because between the date of the 6th and the date of the 12th, your client never went back to her employment. Is that right?
That is correct, Your Honor. However, if you look at the Booker case cited in our brief, it distinguishes, it's not when the last act occurred, it's when the discriminatory practice ceases. And so they call upon the difference in that case, in the Booker case, between the occurrence and the ceasing of the discriminatory act.
Well, if she wasn't there, then it ceased on the 6th, didn't it?
She was still employed by the defendant. It was her resignation action that under the Stevens case that we just cited, that would be considered the constructive discharge event.
So the constructive discharge event is not the transfer on the 6th. You say it's
her resignation on the 12th. Yes, sir. Yes, sir.
Even if she waited another month, that would have been the triggering event. If she never went back to work after the 6th and a month later submitted her resignation, you say that would be the triggering offense.
And if it, yes, Your Honor, we would. However, the argument would then occur if that were a reasonable, after waiting a month to do so, I think it would bring great, big question into the plaintiff's case if that were the case of waiting a month, if the action was reasonable. We're talking about the 6th to the 12th here with a weekend in between.
Okay.
Any other questions, gentlemen? All right. Thank you, Mr. Parker. We will now hear from the appellee.
Thank you, Your Honors. May it please the court. Eric Stevens, Littler Mendelson of the National Bar, on behalf of the appellee, St. Thomas Medical Partners. We respectfully submit that the trial court did correctly dismiss both the harassment and the retaliation claims of Ms. McCain based upon the applicable statute of limitations, and that the court properly found that there was no constructive discharge cause of action that was supported by the undisputed facts in the record and now in the record before this court. I would dare say that it is the rare case in which facts and legal analysis are so clearly isolated. We have harassment allegations that ended June 26th, and I believe Ms. McCain has conceded that. We have a retaliation claim on September the 6th. And if I may take issue with Mr. Parker, I think he said that it was maybe a month and a half. She was actually off work for 2.5 months before she returned to work for 4 hours on September 6th. And then we have a resignation that was 6 days later. Curiously, well, let me back up by saying I would dare say that because we are now live streamed on these arguments, that there are probably plaintiffs' lawyers salivating over the possibility of being able to author a letter for their client that says, "Dear employer, 3 years ago, I was not happy with what you did to me, and I'm quitting today, and you have constructively discharged me." I suggest that that is not the law in this state. It should not be the law in this state. And it would result in nothing more than chaos for the courts as well as for employers if we were to allow that type of reconstruction, if you will, of a statute of limitations. The continuing violation theory, by definition, requires continuation. To the point of the court's question, there was 2.5 months from the time Ms. McCain left work for an FMLA leave that had nothing to do with this case until she returned. It was curious because Judge Armstrong asked what if there would be 1 month before she turned in her resignation letter, and Mr. Parker and candidly said, well, there'd be a question whether that was even reasonable to wait that long. The first of these sections of the case is to remember that Ms. McCain was actually gone for 2.5 months. And after 2.5 months, she returned to work. If Ms. McCain is trying to bootstrap in a retaliation claim over that 2.5 month period, then even Mr. Parker's argument must concede that that is not a continuing violation. The violations must continue for there to be a continuing violation. And in this situation, there was a 2.5 month absence from work. Nothing at all happened. As far as the statute of limitations itself, and it's been referenced in both parties' briefs, but there must be, for retaliation, there must be at least one final act by the employer within the statute of limitations period to avoid the statute of limitations defense, which is what St. Thomas Medical Partners was successful on in this case. I would respectfully submit that the appellant has not come forward with a single fact alleged to have occurred within the statute of limitations period with respect to a retaliation claim. Now, it would appear that the appellant's retaliation claim is sort of daisy chained together. I submitted my resignation on September the 12th. That should draw back in events that happened on September the 6th. And that should draw back in events that happened on June or before June 26th. And therefore, the continuing violation should cover me all the way back to June of 2016. Again, that is not the law. And there is no basis for an extension of that. It would be a complete abrogation of the statute of limitations, as well as the cases that clearly support that even for retaliation, there must be some action that occurred within the statute of limitations. As far as the notion that somehow a letter of resignation would extend a statute of limitations backward retroactively, we cited the court to the Thurmer case, Thurmer versus Charter Communication, and that case stands for the proposition that is not that the statute of limitations starts on the last occurrence of the alleged discriminatory action and not the time of the last effects may have been manifested. To follow the argument of the appellant, we would have to go beyond the effects and actually, to the court's I believe it's Judge Armstrong again that asked the question, when was the last act of the employer? Well, the last act of the employer was on September the 6th. Now, curiously, the last act of the employer on September 6th of 2016 was an act of welcoming back Ms. McCain. I have found in my practice that oftentimes employers recoil at the notion of secret recordings being made in the workplace. We have on the record a secret recording that was made by the appellant. She has taken away any issue of a disputed fact because she recorded what was said to her. She recorded where she was taken. She recorded what she was told. We hear voices welcoming her back, telling her that they hope that she was well, explaining to her what her new role would be. And with respect to whether that was a materially adverse action or rose to the level of constructive discharge, we would submit that the trial court appropriately framed that single issue, and that was whether Ms. McCain was constructively discharged by virtue of the actions on September 6th of 2016. And we, of course, submit that she was not. For there to be a constructive discharge, there has to be an intent by the employer. There has to be actions by the employer to make the workplace so intolerable that a reasonable person would not be able to stay in the workplace. Going back to the notion that there should be some sort of a bridge to September 6th from June, if any of that work was so intolerable, then Ms. McCain would never have returned to work. So by virtue of her returning after 2.5 months, anything that happened before September 6th cannot be resurrected with a continuing violation theory. And so that is gone. And so we look at September 6th. On September 6th, she came to work and stayed for a total of 4 hours. She did not even stay long enough to meet the new physician that she would be supporting. I do want to take one issue with something that Mr. Parker said, and I don't think he meant to be inaccurate, but she did not, these doctors were not co-workers. These were independent contractor physicians that were supported by the staff of St. Thomas Medical Partners, and she was an LPN. She was not a co-worker of any of these physicians. She was told that she was being assigned to a new physician that was just starting the practice. The physician that she had been working for, Dr. John Williams, was the highest volume physician in that practice at that time. It's somewhat disingenuous that when someone would come back from a 2.5-month leave of absence that was because of a motor vehicle accident and likely would put her in a situation that even if she had no issues before she left, that she likely would not be able to keep up with that high of a volume, that she would now complain that placing her with a physician doing exactly the same thing that she was doing. She was an LPN when she went out in June 26th. She was an LPN when she came back on September the 6th. She was simply supporting a different practitioner in that same practice. It would be disingenuous to say, you can't move me to that practice because I might need ramp up time. If she were to have been put back with the highest volume physician, she could have just as easily said, you put me back there knowing that I was not going to be able to physically do the job, and therefore you have constructively discharged me. Instead, she was put with a physician that was new in the practice. She had experience and would be able to support that physician. Now, in her deposition, she admitted she has no idea what that physician's practice was. She did not even stay long enough to find out. The skeptic might say that her alleged panic attack was caused by the secret recording device that she hid in her bra that day. But regardless, it is very apparent that when Ms. McCain returned to work on September the 6th, she was not in a position that a reasonable person would have felt the workplace was so intolerable that she could not return to work. She came for the very purpose of finding a reason for quitting. She came with a recording device. and she was ready to leave regardless of what she was told and regardless of the situation, and that clearly played out in this situation. For there to be a constructive discharge, if there is not a demotion, and by the way, I do want to point out in the Booker v. Boeing case, I would take issue with how clear that case applies here, because in the Boeing case, there was actually, I'm sorry, Gordon versus Stevens, excuse me, I was looking at a different note. In the Gordon versus Stevens manufacturing case, Gordon actually had supervisory duties that were reassigned, and she was bombarded with excessive work when she returned. Very, very different than the situation here. There is no question that LPNs do not have supervisory responsibilities. Their clinical license does not allow that, and she did not contend that she did. She was not even transferred in the sense of a different job. She was simply relocated in the same practice group, in the same building, simply a floor below. Counsel takes issue with makes a point of saying that her coworkers, other nurses, other staff were saying things to her in retaliation for her reporting of Dr. May. Well, first of all, of course, constructive discharge cannot be initiated by coworkers. A constructive discharge must be intended by the employer and not by non-management coworkers. But again, when Ms. McCain was brought back to work, she was placed in the same position, same compensation, same benefits, would be supporting a physician in the same way that she was before, would have less of a work imposed upon her to begin with, and would also be away from those coworkers that she now contends were also contributing to her retaliation. There is simply no evidence in the record that St. Thomas acted with the intent of causing Ms. McCain to resign when they returned her to work on September the 6th of 2016. Ms. McCain's letter, vague though it is, that simply says, I am resigning from my position under duress due to the hostile environment from STMP. You will notice she does not say anything about retaliation in her letter, and counsel has said that it is not the hostile environment harassment that's being appealed. And so, in conclusion, the appellant has not identified a single instance of harassment or a single instance of retaliation that's occurred within the 1-year statute of limitations when the lawsuit was filed. The appellant cannot circumvent the statute of limitations simply by reciting her version of facts that did not exist in a later developed letter. Her resignation was not the result of a constructive discharge. She was not subjected to any adverse action or harassment that would have prompted a reasonable person to resign. We respectfully submit that this case was properly dismissed by the trial court, that decision should be affirmed by this court. Thank you.
All right. Thank you, Mr. Stevens. We will hear in rebuttal from Mr. Parker. You're muted, Mr. Parker.
Thank you, Judge.
Sir.
Appellee asserts that somehow the continuing violation doctrine cuts off or ceases because of the 2.5 months that my client was out for FMLA leave. However, the court must take note that prior to her leave, we have an ongoing investigation in the workplace regarding reports of sexual harassment that my client had made. The defendant had interviewed approximately 5 to 10 co-employees, all within the workspace of my client regarding the allegations of sexual harassment that she was encouraged to make by her supervisor at the time when she learned about what my client was experiencing in the workplace. All of that was ongoing. We had the ongoing investigation prior to her leave. And so that is the backdrop within which we then reach the events of September 6th. And on September 6th, she comes back to work. She is led to a different location. Her computer cards do not work, giving her access to the St. Thomas system in the workplace. She is led to her new location with no explanation of why or what she is doing to go to work for this new doctor, to support this new doctor within the workplace. At that time, she has a medical event. She has a panic attack in the workplace and leaves to seek medical treatment. And it's at that time that her doctor excuses her for an additional 3 days of work and to return on the 12th. And so prior to returning and reflecting on the events of what had occurred over the course since she reported the discrimination, she submits her resignation letter on the 12th, on September 12th. And in that resignation letter, she clearly states, I am submitting my resignation due to the hostile work environment occurring beginning the actions in April when she reported the harassment. The proximity of time, and we've cited in our brief the McPhee case regarding the temporal proximity from when the complaints of harassment originally occurred to when the act of her constructive discharge occurred on the 12th, does give a causal relation to this. So to say that there is this intervening action of her FMLA leave that cuts off the continuing violation simply does not make a good argument to support the defendant's support. What the Stevens case that was issued by this court states that specifically an employer will be charged with a tangible employment action if the plaintiff's resignation is a reasonable response to an employer-sanctioned adverse action officially changing her employment status or situation, for example, a humiliation, demotion, extreme cut in pay, or transfer to a position in which she would face unbearable working conditions. And that's cited that's from the Stevens case. We would say that change of her employment on September 6th was another continuing violation act of the employer in this situation. We still have not heard of any results from any of the ongoing investigation that occurred since she reported the conduct, and all she has received is either harassment by her coworkers, continuing scrutiny by her supervisor, and now she's moved to a different location in the workplace. And so for these reasons, we would state that the trial court erred in not allowing the continuing violation doctrine to apply for this case to continue.
All right. Thank you, gentlemen. Appreciate your argument. We will obviously take this matter under advisement and render an opinion at the earliest possible time. Again, thank you for participating via Zoom. And Ms. Kraft, anything we need to take up before we recess for the call to the next case?
No, Your Honor.
All right, you may recess the court then.
This Honorable Court of Tennessee is now in recess.
Gentlemen, thank you.
Thank you.
Thank you.